Good morning, students. Welcome to St. Wilfrid's Law College online classes. I am Lehar Choudhary and I am going to teach you interpretation of law statutes, module 1 for the 8th semester. And let's start with a very basic definition of what interpretation is actually, it actually means. Now, interpretation in layman language, you can say it as like a conclusion or an idea of what a word means to you. Now, talking in law sense, interpretation is basically defined as taking out a true or a liberal sense of a word or a phrase which is used in a law statute or any judgment given by the courts. It is basically a primary function of the court because as we know that we also have a function of the court as a judicial review, wherein the court also interprets a judgment given by a subordinate court to it or even a higher court to it. Now, this cannot be done arbitrarily or consequently because it tends to change with time and on how a third person or XYZ person is supposed to perceive it. Now, let's move towards the classification of statutes. Classification of statutes, broadly speaking, can be categorized under 3 broad headings, which is on the basis of a duration, on the basis of method, and on the basis of object. Now, coming back to on the basis of duration, they are classified under 2 heads, which is permanent and temporary. Permanent statutes can be defined as statutes which do not have a fixed time duration. I mean, they are long-lasting statutes, which you don't have to, which the government does not have to keep on re-amending or, reissuing them every year. Whereas temporary statutes are statutes which are supposed to be reissued by the government once a year. For example, Finance Act, which has to be reissued by the government every year because finances tend to change and that's how law is supposed to be. It is supposed to change every year. Some examples of permanent statutes can be IPC, which is one of the most permanent statutes which we read. Second on the basis of method is going to be mandatory, imperative or obligatory, whereby it is very implied. Mandatory statutes which mandate you to do an act or a right or obligate you to do a duty, to perform a duty. Now, whereas directive or permissive statutes under the same heading are statutes which are not, they don't tend you to give directions or they don't take your rights away, but they direct you, they give you a procedure how to follow your rights, how to go about it, and either you are supposed to take a permission under those acts or you have to follow a procedure. For example, Civil Procedure Code. There is a particular procedure how you are supposed to go about calling a witness. How about you have to go for civil appeals in the High Court. There are several procedures which are mentioned under the law statutes. Now, coming to the most important heading is on the basis of object. Object meaning what is the crux of the act you are going to do, what is the problem on which the statute is being performed. Now, let's get started. Now, the first one is codified statute. Codified statutes are statutes which codify a particular law on a particular topic. For example, Hindu Marriage Act, Hindu Succession Act. These are particular topics related to one particular term. इसके अंदर एक ही टॉपिक के ऊपर आपको precise and to the point notes मिलते हैं, to the point law मिलता है. The code contains pre-existing provisions in different statutes on different subjects as well as common law on it. Hindu Marriage Act, Hindu law के पर्टिकुलर एक्ट्स है हमारे पास जिसके अंदर पर्टिकुलर प्रोविजंस हैं. नाउ सेकंड इज कंसोलिडेटिंग स्टैट्यूट्स. कंसोलिडेटिंग स्टैट्यूट्स are on a particular subject at one place. For example, Rajasthan Rent Regulation Act. Therefore, what it does is it basically consolidates a particular law for a particular place so that it is easy to segregate and easy for the people to understand how law has to be performed in a particular area or a society. Now, moving further, there are declaratory statutes, in which these are statutes which are enacted or made forth to amend or remove ambiguities from previous existing statutes. Now, for example, I can give you Income Tax Amendment Act 1985. This was an act which was made or which had come into force to remove certain ambiguities which had been pre-existing in the Income Tax Act, which was issued before by the Indian government. Now, one of the most important things regarding these declaratory statutes is that they have a retrospective effect, but only on those acts or only on those cases which are done after the issue or after the particular amendment act or declaratory act has come into force. Now, for example, this amendment act, Income Tax Amendment Act, was enacted in 1985. We're just considering it as an example. Now, 1985. Now, for example, there was an act or there was a commission of a crime regarding whatsoever income tax related crimes are happening. There was a act or a crime which was which happened in 1999, and there was an previous judgment which had occurred like 1984. But then this act will not be applicable on this act. It will only be applicable to this. Previous judgments cannot be changed on the basis of the provisions or the amendments made in the Amendment Act of 1985. Now, there are remedial statutes. Remedial statutes are basically statutes which provide you remedial acts for your commissions of crime. Though every act in our law, Indian law, has certain amount of remedies provided under it. But there are certain acts which are only provided for remedial purposes. For example, Specific Relief Act, which only provides you remedies wherein particular acts are done, or even where certain acts are not done according to the law. Now then, coming to enabling and disabling acts. Enabling acts are those acts which enable you or give you a right to perform a certain action or a duty, wherein you are allowed and you are permissible by the law and courts to perform a certain act. Wherein disabling acts are which restrict you from performing duties. They go hand in hand, but still, all acts can be considered under enabling and disabling acts. For example, even the Indian Constitution gives you certain rights and takes away your rights, which are considered enabling and disabling acts under the Indian law. Now, taxing acts are those acts which impose taxes on the people and the government personals. For example, the Income Tax Act. Now, explanatory acts, self-implied. कोई भी एक्ट जो आपको एक पर्टिकुलर चीज के बारे में एक्सप्लेन करेगी. फॉर एग्जाम्पल, हिंदू मेंटेनेंस लॉ, चाइल्ड एंड अडॉप्शन एक्ट गिव्स यू अ पर्टिकुलर प्रोसीजर एंड अ profile how to go about it, how a person, for example, XYZ person is supposed to go with an adoption of a Hindu child. These acts give you a particular explanation of how you are supposed to go about it. Now, amending acts. Any act, for example, Act A, and wherever you find this word amended, wherein previous law was corrected, previous ambiguities under the acts were corrected, are supposed to be amending acts. Example for amending acts can be Hindu Marriage Amendment Act, which was an amendment to the previous act, wherein some certain changes were done. We've also had amendments in our Indian Constitution. I think you are very well aware of that. Now, there are repealing acts. Not different, but still have a minute difference amongst the amending and the repealing act. Repealing act is basically the previous act was absolutely deleted. The act which has come right now is absolutely pursued new. You have no previous laws or considerations regarding the next following act which is supposed to repeal the previous one. Now, curative or validating act. Curative or validating acts are basically taken out to validate or create cure the previous acts which have been already used, have been used by the people in time in force. Now, the basic examples are Maintenance and Adoption Act, because there have been certain ambiguities. Beforehand, we used to have these acts under the Hindu law, Hindu Marriage Act only, but then since it was a very complicated topic for the people to understand, and there were no specific rules as to how maintenance should be given and how adoption of children should be pursued by a normal being, there are thousands of cases and scenarios which could be followed. But then now, since we have a particular act which was made basically to remove the ambiguities and the complications which were faced by people to understand and interpret the laws which were given under our Hindu Marriage Act and Hindu Family Law Acts and all those. Now, coming forth, also a part of statutes is what is basically a bare act basically. Now, when we read a bare act, we usually don't take in consideration as to what parts are we reading about. Now let me come to a point where we are going to read that what are exactly the parts of a statute. Now starting from is a short title, which is basically mentioned above section 1, just on the first page, just on this first page of the, above this section 1, which is basically the short title itself. It is titled that way actually. Now, for example, if I take an example of Sales of Goods Act, short title basically is given over here. It is an act to define and amend the laws relating to the Sales of Goods Act. Now, this is supposed to be the short title, wherein section 1 itself is named as short title. Now, coming to the second is long title. Long title can be defined as where it is expedient to define and amend law relating to the Sales of Goods Act. This is the long title about, basically it gives you a gist of how and what exactly is this act or particular statute is going to tell you about. It gives you a crux of what this act holds inside it. Now second, coming to a preamble. Preamble, we all know that is only situated in one of the acts which we follow is the Indian Constitution, and you know very well what it means. Preamble basically gives you all the rights of what a person or people of India are supposed to endeavor from the Constitution of India. It provides you with the basic crux in a paragraph form of what the Indian Constitution or any act which has a preamble to it will be giving or setting forth. It may also be termed as providing you aims. Preamble also sets goals in front of you as to what a person thinking before this act wants to give you an aim in front of the people. Now, there are marginal notes, footnotes. These are topics. These are basically marginal notes give you an heads up about what your initial or prior things have happened and where you can take an example of cases. Now, in this particular act, you have marginal notes which are given at the bottom of usually they are written or printed at the bottom of a bare act, wherever you need to find. Even in our projects, we tend to add headings and marginal notes. So now, for example, here, and marginal notes are supposed to be basically, if you have a word format, they are supposed to be linked to the particular place from where you have taken as. So they give you a heads up from where exactly the sources of the arising of the law is. Now, this is, for example, for the statements of objects and reasons and for report of special committee. See, Gazette of India 1929. So, for example, particular footnote was taken. The source of the particular footnote was the Gazette of India to 1929, page number whatsoever, so and so, so and so. Now, coming to the fifth part is headings. Headings are supposed to be give you a particular point wherein you have subheadings and then you have subheadings under which you are classifying things as to how they are going to go. Like, for example, we have chapter 1, then we have preliminary. Then after preliminary, we might also have miscellaneous. Miscellaneous might include different and extra definitions which are required for the person to understand. Now preliminary means they give you a basic information as to what the act holds. They might give you definitions about how it is supposed to be. They also give you application and procedure as to how to follow, and so on and so forth. Now definitions. Definitions are usually mentioned under section 2 of every Bear Act or most of the Bear Acts, wherein particular terminologies which are used further in the Bear Acts are particularly defined so that it is easy for a person or a student to be able to interpret them accordingly. For example, fault is defined under section 2(5) of the Sales of Goods Act as wrongful act or a default. So for example, if there is a further mention of a word fault under any act or under any provisions under this particular Sales of Goods Act, you're supposed to consider it as a wrongful act or a default from the X party or the Y party, whomsoever you are considering it to be. So therefore, it is usually given under section 2 of these acts, Bear Acts. Now coming to punctuations, which play a hand role under any law or any judgment or any thing which you consider to be for your law perspective. Now punctuations play a very important role, as then even a pause or even a full stop might change the way of how the court might interpret it or how you might interpret it in a particular manner. Now for example, if there is supposed to be a comma between two words and the judge does not find it and he does interpret it in a wrong way, you might end up with a wrong judgment in a wrong judgment. But then that is why it is very important. It changes the meaning of the sentence itself. Now coming forth, it's provisos and exceptions. Exceptions and provisos are basically, they give you a heads up or they give you a idea of what can be a plus situation of the existing act if it might happen. It gives you a, it gives you a, for example, अगर ये नहीं होता तो क्या हो सकता था? It gives you this ideology. So it gives you a particular situation wherein you need to act or enact a particular law in a certain way. Now explanations to a section are basically to ease the person's interpretation who is reading it or who is trying to implement it. There is no hard and fast rule you need to read the explanation or anything, but then it is basically to ease the teachers or the students or the judges or the person who is handling a case to understand the above given law. Now coming to the last one is schedules. Schedules give you a particular right and the power how to claim those rights. For example, schedule number 7 under the Indian Constitution gives you, what does it give you? Seventh schedule gives concurrent list and the state list. Concurrent list and the state list. Now coming to the third and the last topic at how is it different from the construction is, now interpretation, we know the meaning of interpretation, which is true and the liberal sense of a word or a phrase which is used under any law or any act. Now these two terms, construction and interpretation, are used synonymously, but they are different. Now how different? Interpretation is basically a true and a liberal sense of a meaning, but whereas construction is a conclusion on the true spirit which might and might not differ from the true meaning. Construction is basically how you perceive and how you conclude that word and meaning to be. Now for example, there are two words which might mean the same thing, but for example, a judge sitting there takes it as a different way, in a different way. So you don't have to get confused among how these two words are used, because conclusion is not the main part. The main part is interpretation and how you're supposed to do, and how basically the courts and the judges are supposed to do. There are certain sets of rules and applications to be followed by the Indian courts and the government and also the students. So in the next lecture, we are going to read the second part of the module, which basically deals with rules of interpretation. Thank you.